It gives me a great pleasure tonight to welcome everybody to the John Marsden Memorial Lecture. I'm Cameron Murphy, the President of the New South Wales Council for Civil Liberties. I just need to apologise. Our Senior Vice President, Pauline Wright, was supposed to be acting as the MC tonight. She's also a member of the Law Society's executive, and she's been detained at their conference in the Southern Highlands, and I don't think she'll get here until much later, so I'm standing in to do this role as well. I'd first like to welcome everybody to tonight's lecture. It's wonderful to see such a turnout, and I'd also like to acknowledge that the lecture's being held on traditional lands, those of the Gadigal people of the Eora Nation. I'll just quickly run through tonight's order of proceedings. We'll start with a quick introduction by Jim Marsden. We'll of course next hear our guest speaker for this evening, Nicholas Cowdery. After that, I'll say a very short word of thanks, and then guests are invited to remain for further refreshments and discussion after the lecture. So I won't hold you up any further, but I'll call on Jim Marsden to introduce our guest speaker for this evening.
Thank you, Cameron. Pardon my voice. Whilst Cameron appropriately acknowledged the traditional owners of the land, my job is to acknowledge the sponsors of tonight. A little bit different, but nevertheless, it is important, and I acknowledge Bradcorp, Peter Brannan and Graham Kelly, who's here tonight from Bradcorp, who've been sponsors of this event since we started 6 years ago. And of course, Marsden's Law Group. And we'd love to hold this event out of Campbelltown, but I don't think we get most of you young city lawyers out there, or most of you civil libertarians out there, as much as we'd love you to come out to the real world and see what we consider still to be God's country. And as my late brother John described it, there were two great cities in the world, Rome and Campbelltown. I had that discussion with somebody just the other night, and they were a bit surprised. They didn't know John, they were a bit surprised. He'd just come back from Rome, he'd known Campbelltown, and he couldn't see the comparison, but there again, John did, and John loved to make the comparison. I read an article recently from a Greek counsellor, and she was talking about the fact that quite often when somebody dies, when somebody passes away, their presence is greater then in their death than it was when they were alive. And I immediately thought of my two brothers, but in particular John, as we were coming up to tonight. There's no bloody way that's the case under any circumstances. John, during his life, was, as those of you who knew him, and some of you who knew of him, was larger than life. And for me, as his little brother, he was a presence that was there forever. For his sisters that he hears tonight, and his other brother who's passed away, he was there forever as well. But John was a man that had a commitment from the beginning of his life, probably because of his homosexuality that he struggled with very early, had a commitment from the beginning of his life that he would do good, do well for other people within the community, other people that have similar types of struggles, other people that don't have the wherewithal to deal with the issues that are presented to them in life. And John, with that within himself, just expanded beyond his family, beyond his beloved city of Campbelltown and the people of Campbelltown, to the state of New South Wales, into the country of Australia, to the legal profession, to the Council of Civil Liberties, to the Law Council, and all of those kind of areas. And when John was doing all this, some would at times say unkindly for his own gratification, the ones that mainly said that were me and my sisters. But it wasn't for that ever, really. I mean, he enjoyed the fame that he got in life, as most people do. But what John was doing, he had a commitment, and he was fulfilling that commitment. He took many causes on, and he took them on with courage. And he always, most often, did it in a confrontational way where it was necessary. No matter how he did it, however, he was always seeking to achieve change. Michael Kirby, who's here tonight, said in his eulogy to John at his funeral that John described him as the change agent, and in many, many ways he was. But most importantly, from my observation as a brother, he was a person that was always seeking not just the change, but was seeking justice. His end role, his end focus that he never ever deviated from was to seek justice, social justice and justice for all. Never deviated from the rule of law. It was, as a lawyer, he loved the criminal law. He didn't just do the criminal law. When you practice in the suburbs, you don't have the luxury of being able to do a simple specialty. But he loved the criminal law. And he loved the criminal law because that gave him the opportunity to get out there and see that justice was done. And I think it's appropriate, therefore, that we have probably the best criminal prosecutor that this country, not just this state, has seen to present the John Marsden lecture tonight. And it gives me great pleasure, therefore, to introduce Nicholas Cowdery, AM, QC, BA, LLB, FAAL, and there's probably a few others there that I didn't recognise, so I can put them in. Nick was the Director of Public Prosecutions for New South Wales from 1994 to 2011. He presently is an adjunct professor at the University of Sydney and Charles Sturt University, a visiting professorial fellow at the Universities of New South Wales and Wollongong, which awarded him an honorary doctorate of laws in 2011. He's a member of the Order of Australia, which was awarded to him in 2003 for fostering international relations in the area of human rights and for services to the criminal law. From 1999 to 2005, he was president of the International Association of Prosecutors, and I understand Nick is still actively involved in that association. I noted somewhere that he actually attended Wollongong High School, and he agreed with that, and he also said that after Wollongong he moved out to West Wyalong, and I pointed out to him that it was only a stone's throw, just a little spit away from that beautiful town of Marsden, and he did recognise that he actually had to drive through Marsden to get to West Wyalong. He then eventually graduated in arts and law from the University of Sydney. I wouldn't normally mention what college he went to, particularly given what's happening, but I'm pleased to say that he attended St Paul's College. During his time as Director of Public Prosecutions, he led the prosecution of some of the most famous cases of recent memory. He is the nation's longest serving Director of Public Prosecutions, and most importantly, I think most of you would remember that he was renowned for his fierce determination to remain independent of politics. The job, the charter that sets up the position of Director of Public Prosecutions requires that this be done. The rule of law requires that this be done. Politicians, unfortunately, don't always recognise that and don't always recognise the rule of law. Nick, despite the efforts to change that, always made sure that it remained that way. Ladies and gentlemen, it gives me great pleasure that I introduce Nicholas Cowdery.
Thank you very much, Jim, for your generous introduction, and good evening, ladies and gentlemen. Thank you for the invitation to deliver the John Marsden Memorial Lecture this evening. There is a written document which bears that title, which will be available later, I gather, on the website and perhaps by other means. I will be talking this evening about less than half of what is contained in the document, because time is limited, but there were other details that I thought needed to be included in the lecture to flesh it out, to give it some body and some strength. So you will be able to read the rest of it at some later time. In this Masonic centre, you will occasionally hear a rumble from underground, from below. Part of the rumble that you hear tonight will be Sydney's Underground Railway. part of the rumble that you hear tonight will be the sound of John Marsden turning in his grave as he contemplates the idea of a former Director of Public Prosecutions delivering this lecture. But it really is, I think, a sign that the times are a-changing, and at least in that respect, I hope for the better. It's a great privilege in this way to be able to acknowledge John's adherence to principle in the conduct of his criminal law practice, to the rule of law, as Jim has already mentioned, to the protection of human rights in the criminal justice process, which is absolutely essential. I know from often painful, always direct experience that he was concerned to see that the criminal law was applied appropriately and, of course, beneficially for his clients. One can only imagine how he would have reacted to some of the changes around us at present. Because change is in the air, and in some aspects it has already landed. Of course, the criminal law is in a constant state of change, and so it should be, because society develops and changes, and the law needs to change to accommodate those changes. It needs to adapt. And it will usually make those changes a little bit behind the pace, a little bit conservatively. Perhaps not as quickly as people like John might prefer change to occur, but change happens. The law should be conservative, but sometimes it jumps ahead too precipitately, usually in response to some short-term political imperative. And Jim has mentioned some of the stoushes that I had with politicians, with the media from time to time, when change of that kind was sought to be introduced without proper consideration. It's to be hoped, of course, that all change equals improvement, but regrettably that is not always the case. There are a couple of examples just in the last few days that I would like to mention. One is from the American elections. You will know that there's been a presidential election, and at these times the Americans vote for everything from the president down to the dog catcher, and legal initiatives that are put forward for the vote of the populace. In two states, in the states of Washington and Colorado, there has been a vote in favour of the legalisation of cannabis. Not just making it available for medical purposes, but the full legalisation, regulation and control of the distribution of cannabis. And that is an enormous result. On the other hand, other change, which is not so good, is something that was drawn to my attention only yesterday, where the Attorney General of Queensland, and yes, we know that Queensland is another country where strange things can happen, the Attorney General of Queensland is proposing to introduce legislation that would, amongst other things, enable drug traffickers, convicted drug traffickers, and it doesn't matter much how much is involved in the trafficking, to have a declaration made against them that they are drug traffickers. And the consequence, or one of the consequences of the declaration, is that all their assets that they held at the time of the making of the declaration can be forfeit to the Crown. And the onus will be on them to prove that they were not unlawfully acquired. So you see, some change indeed is not so good. And I'm going to talk about some changes here in New South Wales, some of the changes that we're presently experiencing. Of course, there's a great deal more that's happening that I won't be able to cover. But I'm going to touch on 5 areas of legal change. The first is bail laws. The second is sentencing laws. The third is the right to silence. The fourth is the position of serious violent offenders. And the fifth is the topic of drug law reform, which is a subject which I think has entered its day for discussion. And as I go through those areas, some of them quite briefly because the time won't allow a long explanation of exactly everything that is happening. But as I go through them, I'm silently posing the questions. Is change required? Does principle support it, as opposed to some short-term political advantage? Are principles being violated by change, or even by reaction against change, perhaps in repetitive ways? What improvements will change make, and what additional harms will it cause? So those are the questions that lie behind the areas that I'm examining to some extent in what I have to say this evening. Well, the first is bail law reform. And there's been quite some publicity about it in the general media and elsewhere over recent months. This audience would know that in the criminal justice process in our jurisdiction, the person arrested and charged with an offence is brought promptly before a magistrate in order for his or her disposition pending a court appearance to be determined whether or not to be released on bail or to be remanded in custody. And if released, on what terms and conditions. Similar decisions, of course, are made at later stages of the hearing of any criminal matter. Now, before 1978, here in New South Wales, all those proceedings were dealt with under principles created with a very few minor legislative interventions by the common law. Law made by judges as the courts dealt with individual cases, and superior courts identified and confirmed the rules that should apply generally in particular circumstances. For all the benefits the common law has brought us, however, it can lead to uncertainty and sometimes inconsistency, qualities that are not beneficial to criminal justice and to community confidence in the criminal justice process, without which it would not survive as it does. But in the pursuit of certainty and consistency, we must be careful to adhere to principle and act always in the general public interest. Now, it must be clearly understood, and it's very often forgotten by commentators and by politicians, that bail has nothing whatsoever to do with punishment. That comes to be considered only after conviction. The person being considered for bail still carries the presumption of innocence, and that is not a glib slogan. It has meaning. And traditionally, there are three tests that must be applied before an order is made granting or withholding bail. What are the prospects of the accused appearing in court on the next occasion? Is there a prospect that the person will commit further offences if released on bail? And is there a prospect that the person might interfere with evidence or with witnesses if granted bail? Those are the three traditional tests that magistrates and judges have to weigh up and assess before they decide whether or not to release somebody on bail. Now, in 1978, there was a small legal revolution in New South Wales when, for the first time, we had a Bail Act passed. And it codified the law on bail for the first time. We hadn't had an Act of Parliament that dealt with these matters. And the essential scheme of the legislation was actually quite straightforward and quite simple. There were some offences for which there were presumptions in favour of bail. There were some offences, the most serious kinds of offences, as you might imagine, where there were presumptions against the grant of bail. And then there was the whole middle ground, where there was no presumption one way or the other. And of course, there were provisions there for how the bail regime would be administered and what sorts of considerations would be taken into account by the courts. And that was seen as great progress. It was seen as a big step forward. That was 1978. We reached a position last year, 2011, where that simple scheme had been complicated enormously by incessant tinkering with the Bail Act by governments, and particularly in the last 15 years or so. I won't identify the particular government at that time. You would work that out for yourself. But those tinkerings seem to have been the product of two forces. And these forces operate generally in the criminal law as well. The first was the government's general tough-on-crime attitude. And no single party government has a monopoly on that. The tough-on-crime approach conflated the idea of bail with punishment, and the idea of using bail as an instrument of punishment and control. The second influence was the government's sensitivity to publicity and pressure from the radio shock jocks, the tabloid media, the police association, and other lobby groups in the community. And occasionally there would be some well-reported incident where perhaps a juvenile on bail committed another offence, breached his or her bail conditions, and there was a great outcry for legislative amendment to fix this, to stop this happening in the future, as if it could. Because you can legislate for things, but actually making them happen requires the agency of a whole lot of others in the application of the law. So there were these piecemeal amendments to the Bail Act. Presumptions in favour of bail were reduced. Presumptions against bail were increased. Circumstances where exceptional circumstances needed to be proved to allow bail to be granted increased. And the procedural requirements were restricted and limited and made more onerous on those who were seeking to apply for bail. And it was a general movement in that direction by a whole mishmash of legislative changes that were made over a long period of time. And it got to the stage, I venture to suggest, where there was a great deal of confusion and disorder in the way in which the courts went about the business of deciding whether or not to grant bail, because they were constantly trying to interpret and apply these changes that were happening constantly. Back in 2010, before the change of government, there was a simultaneous editorial run in the Sydney Morning Herald in Sydney and in The Age in Melbourne on the same day. It was in almost exactly the same terms. And it was headed The Disappearing Right of Bail. And it said, as the New South Wales government steadily piles on new categories of serious crime in response to the latest crime scare, ramps up mandatory sentences, restricts bail eligibility, and most recently throws away the key for convicts perceived as unrepentant, we are entitled to ask what returns in safety we are getting from our billion-dollar-a-year jail industry. On a more humane calculation, we should be asking what damage is being done to individuals and society by this pursuit of vengeance. Of course, there will always be a few who go out and commit new crimes while on bail or parole, and set the tabloid dogs barking again at the Attorney General. If jail workers reform, the lock-'em-up philosophy might have more appeal. Unfortunately, the statistics show New South Wales also has a much higher recidivism rate than Victoria, the revolving door of the prisons. It's still the case this year, in 2012, that about 25% of the New South Wales prison population, which, yes, over the last 12 months has fallen, 25% remain unconvicted, bail refused. About 1/3 of the adults on remand, that is in custody, refused bail, will be acquitted or sentenced to non-custodial penalties. And bear in mind that in our system of justice there is no compensation available for them for their time in custody. More than half the juveniles in custody are there not because they've been found guilty of an offence, but because bail has been refused. They are involuntary students in the University of Crime, as it has been described, I think, with some accuracy. Well, we had a change of government in March last year, as we all know. And in June of last year, on the 9th of June, the government announced a review of bail law by the Law Reform Commission. Its time to report was extended to the end of February this year, and it reported then, and on the 13th of June, the Attorney General tabled in Parliament the Law Reform Commission's report on bail. And you will see references to this in the written paper that you'll be able to see. The Law Reform Commission set out a number of principles in the executive summary. I'm not going to go through all of them, but one of the paragraphs in the executive summary says this: the criminal justice system has embedded within it the value of personal liberty and a suite of cautionary concepts and principles which recognise and protect the value of liberty. These include the presumption of innocence, no detention without legal cause, no punishment without conviction by due process, a fair trial, individualised justice, and consistency in decision-making, and the special consideration required in relation to young people. The principal approach of the Law Reform Commission is set out in this paragraph. In a new Bail Act, the scheme of presumptions, exceptions and exceptional circumstances in the current legislation should be replaced with a uniform presumption in favour of release, applicable to all cases except those covered by an entitlement to release and appeal cases, which are dealt with separately. So the Law Reform Commission has recommended an approach that incorporates a uniform presumption in favour of release. Well, needless to say, once the report was tabled, there was public reaction. From shock jocks, from the tabloid media, from all the sources that you might expect. Richard Ackland, in his column in the Sydney Morning Herald on the 15th of June this year, said this: who would have picked the hardline Christian warrior, Attorney General Greg Smith, as a lefty masquerading as a conservative? I can tell you I wouldn't. He was one of my deputies for about 4.5 years. That's the verdict, said Richard Ackland, of 2GB's morning show judge and juror, former taxi driver and game caller, Ray Hadley, talking yesterday about the New South Wales Law Reform Commission's review of the Bail Act. His studio claqueur was the Telegraph reporter Andrew Quinnell. It's a very sad day when Andrew Quinnell moved from the Sydney Morning Herald to the Telegraph. He went on, Connell thought this was one of the most left-wing reports on law and order. The opening line of his story yesterday said, accused murderers and rapists would be allowed out of jail while awaiting trial under an overhaul of New South Wales bail laws. Ackland continued, talk about parallel universes. Ray and Andrew must have a version of the report different to the one everyone else is reading. That it is so overdue for a clearer and fairer bail act hardly needs to be stated. The cacophony of populist fear-mongering against such a plan shows the uphill battle Smith faces in getting even the most elementary improvements through Cabinet, let alone Parliament. Well, that battle continues, and it remains to be seen what of the Law Reform Commission's recommendations will be taken up. It seems to me that the report presents compelling arguments for reform of the New South Wales bail laws. It draws attention to the fundamental principles behind bail, the processes that must be available, and the manner in which the powers should be exercised. The soft or tough on crime arguments will no doubt continue. But another slogan that I like is smart on crime. It needs to be heard more often. When laws such as the Bail Act become instruments of injustice, it's time for change. And the Law Reform Commission report provides an opportunity for such reform, and it's to be hoped that the government will seize the opportunity to act in a principled way. So, Greg Smith, we're still waiting. Sentencing laws, also by a process of legislative interference, got to the stage where they became almost impossible to apply in a rational and logical way. And I know that because when I was DPP, one of my tasks was to review sentences that were referred to me for consideration, to see whether or not there should be a Crown appeal against the sentence, whether or not there was a viable argument that the sentence was manifestly inadequate. It became a bit of a game to spot the error in the judge's remarks on sentence, sort of an intellectual challenge, but unfortunately a challenge that was all too easy to meet. Because despite the hard work that they put into getting sentences right, judges just found it impossible to deal with all of the injunctions contained in the Crimes Sentencing Procedure Act, which had been changed and amended and added to over a period of about a decade or more, to the point where considerations the judges were required to bear in mind became contradictory, unable to be resolved one against another, and almost impossible to cover comprehensively in the sentences that they were imposing. When I started practice at the bar, remarks on sentence might be about half a page long, and everybody knew what the principles were behind the sentence that had been imposed. And everybody accepted, because that was really all the judge needed to say. Now, if you can find remarks on sentence, even from a district court, of less than 30 or 40 pages long, you're doing well. That's because of what one judge has described as the laundry list of matters that need to be taken into account and ticked off as you go through, for example, the provisions of Section 21A of the Crimes Sentencing Procedure Act and other requirements that are there. And of course, judges will get it wrong. That doesn't mean there's an appeal in every case where a judge is erred. Of course, the test is still whether or not, for the Crown, the sentence is manifestly inadequate. Well, fortunately, the new government has intervened there also. one of the things that has caused enormous difficulty since it was introduced in 2003 has been the standard non-parole period regime that was introduced into that legislation. And whether or not it was the intention of the government at the time, in 2002, it has certainly been the case that the standard non-parole period regime has increased the number of sentences of imprisonment and has increased their length. The New South Wales Judicial Commission has published reports that demonstrate that quite conclusively. It's a bizarre scheme. It gives you a little bit of an idea about how laws are made in New South Wales. They list offences. They then list standard non-parole periods that should be imposed for those offences. And a standard non-parole period is a non-parole period that is to be imposed in a case that is in the middle of the range of objective seriousness. Put that one out. The standard non-parole periods range from 17 to 70% of the maximum penalties prescribed for those offences. How on earth could that have happened? Well, the reason we are told is that they went back through the Judicial Information Research System, the JIRS sentencing statistics, and pulled out the median sentences imposed for those offences over a period of time and made those the standard non-parole period. Now, I'm not going into the logic of that. On the day that the legislation was being brought before Parliament, there was a particularly gruesome story on the front page of the Daily Telegraph. I still remember it, where somebody had been sentenced to a term of imprisonment for a particularly nasty child sexual assault. And the Telegraph was up in arms. The sentence was inadequate. This person should have had a sentence of at least double what had been imposed by a very experienced judge, I think, doing his best in the circumstances. This is on the day that the legislation was due to go to Parliament. Before it got into Parliament, 2 new offences had been added to the list of offences under Section 61N of the Crimes Act. They didn't have time to renumber all the offences in the schedule, so they called it 9A and 9B. And there's still 9A and 9B. That's the way legislation happens, sometimes in New South Wales. But that regime has been challenged. There have been some High Court decisions that have been addressed to it, most recently in a case of Muldrock, which has really put the cat amongst the pigeons because it's taken a lot of the force out of the standard non-parole period regime. And it remains to be seen how that all is resolved. It's a work in progress at present. Back in 2010, the Chief Judge of the District Court here, Justice Blanche, spoke at a Legal Aid Commission conference. And during that conference, he said this: 40 years ago, murderers received a life sentence, but most were released after serving 10 to 15 years. And that was generally regarded as the most serious of offences. It was unusual for a prisoner to spend more than 20 years in jail. It was then generally accepted that prisoners became institutionalised after serving 5 years in jail, and that after 10 years they would have extreme difficulty coping with living by themselves in the community. I suspect, said the Chief Judge, little has changed in that regard. We also should ask if our community is now any safer and less prone to crime because of the increase in sentences. The $1 billion a year prison industry. Well, I've referred to recidivism, and New South Wales has quite a high rate of recidivism. So maybe the time that people do spend in prison before their release is not being put to its best use. In a column a little while ago now, Ross Gittins in the Sydney Morning Herald wrote about this. And I'm sure you are aware that Ross Gittins is the economic editor of the Herald and a very prolific and well-respected columnist and commentator on economic issues. And he asked this question: how would you go about reducing recidivism? You'd do it by putting a lot more effort into rehabilitation while people were in jail or after they'd been released. Would it work? According to a big US study, yes, it would. It finds, the study, in descending order of cost effectiveness, vocational education in prison, intensive supervision using treatment-oriented programs, primary or secondary level education in prison, cognitive behavioural therapy, and drug treatment in the community are particularly effective. These programs would have a cost, he said, but they'd end up saving a lot more than they cost. Of course, as well as saving the taxpayer money, they'd achieve a reduction in crime, the thing we supposedly care most about. One thing they wouldn't be, he said, is politically sexy, which may explain the public's, the media's, and the politicians' lack of interest. Well, I would suggest the only way to engage the politicians' interest, in whose hands law reform lies, is to communicate with them more and more, to make it known what the community wants to see happen. Well, there is now also a Law Reform Commission inquiry into sentencing laws in New South Wales. The deadline for reporting has been extended to March of next year, and a great deal of work has already been done. And you can see the results of the work so far if you go to the Law Reform Commission website. See the, I think it's 14 question papers that have now been posted on that website, which each provides a very good potted history of the particular issue that the question paper addresses. So it's a very good educational resource, as well as being a tool, hopefully, for law reform. People who have an interest in this area should make submissions to the Law Reform Commission. That's the way in which considerations are going to be taken into account. And that's the way that we can most effectively promote change. The third point to talk about is the right to silence. Now, the right to silence is understood as an idea in the legal community. The only place where such a right is actually provided for in international instruments, as far as I can see, is in Article 14.3g of the International Covenant on Civil and Political Rights, which provides the right to any person suspected of crime not to be compelled to testify against himself or to confess guilt. Now, the rest of what we call the right to silence is really a collection of privileges that are enjoyed by a suspect of crime and a person who is being tried for a criminal offence. So, the privilege not to be required to answer any questions in interrogation. The privilege not to be required to give evidence in the case against him, with no adverse inference being drawn for exercising that right. Because if you have a right and you exercise that right, it's quite illogical for there to be any sanction, any disadvantage, any penalty attached to the exercise of the right. One of the frustrations that was voiced in the media last year, beginning of this year, here in New South Wales, was the refusal of victims of crime, people who were in houses that were being fired at by passing gunmen, to cooperate in the investigation of those offences. And you can understand the frustration of the law enforcement agencies in trying to conduct those investigations. Of course, it's widely believed that these incidents were connected with turf wars over drug distribution, and so it might be that people who were the targets of these attacks might be very reluctant to talk to the police about a whole lot of things. But that's beside the point, in a sense. On the 12th of September this year, only a couple of months ago, the Attorney General announced amendments to the law, or planned amendments to the law, to qualify the right to silence. And in his media release of that date, he said, last month, the government announced plans to allow juries and judges to draw adverse inferences against alleged criminals who refuse to speak to police but later produce evidence, in inverted commas, at trial. There was no lengthy explanation as to why this was considered necessary or appropriate in the present environment. We pride ourselves on the fact that the criminal justice system in New South Wales is based on the English common law system of criminal justice. It's been described, I think, with some justification, at least so far as accused persons are concerned, as the gold standard of criminal justice. Most criminal lawyers, I think, would regard that gold standard as being based on some of those principles that I've already referred to. The presumption of innocence, trial by jury, requirement for the Crown to prove an allegation beyond reasonable doubt, the right to legal representation, the right to confront an accuser by cross-examination, and, as is described, the right to silence. Well, there have been a number of submissions put forward as to why the law should not be changed, to allow adverse inferences to be drawn against people who refused to speak to police in the initial part of the investigation, but who later seek to produce evidence against their guilt. One of the submissions, and I've given you in the paper the reference to the website where it can be found, is a submission of the New South Wales Bar Association. It argues that the current legislative scheme does not require reform. It points to a number of examples of requirements on the defence already for disclosure of information. The question of an alibi, where notice must be given at least 42 days before trial. Otherwise, the evidence cannot be led without the agreement of the trial judge. It refers to a case where somebody charged with murder seeks to lead evidence of some substantial impairment of mental functioning, what used to be called diminished responsibility, which was much easier to get done around. But in those cases, the defence must produce notice of the name and address of the witness who is going to provide evidence of that substantial impairment. Where the defence of mental illness is raised, it is usual for the defence to disclose psychiatric evidence in support of that defence. And there are also case management procedures that are set out in the Criminal Procedure Act, which allow application to be made in particular cases for trial judges to make orders for case management steps to be taken in particular cases. Yes, admittedly, very few such applications are made, but the facility is there in appropriate cases. In the submission, the Bar Association says that another justification given for the proposed limiting of the right to silence is the difficulty facing police, and I've said this, faced with drive-by shootings, because victims and eyewitnesses sometimes refuse to cooperate with the police. Submission says the watering down of the right to silence, however, is really irrelevant to such cases, because only people suspected of or charged with crimes have the right to silence. An eyewitness to a crime, and indeed any person in possession of information which might be of relevance to police in apprehending an offender who does not bring it to the attention of the authorities, commits an offence against Section 316 of the Crimes Act, concealing a serious offence. We've had some publicity just in the last few days about, for example, the situation of Catholic priests who receive information in the confessional, and the question of whether or not that should be required to be disclosed, or whether it may be kept confidential and secret. It's said that the current proposal to limit the right to silence is based on the English model. Now, you've probably all seen the old episodes of The Bill, where the new caution is administered to people. I'm not going to repeat it, but it includes the words to the effect that if you fail to mention something that you later rely on in evidence, that might be detrimental for you, or worse to that effect. The difficulty about that is that when that provision was introduced in England and Wales, lawyers were put into police stations to be able to give advice to suspects on the spot before they were interviewed. And the relationship between the police and the lawyers was such that the lawyers could get information about the allegations against the people they were advising before they gave the advice. No such scheme is proposed in New South Wales. The furthest the government has suggested it might move in that direction is to have a pilot system of a telephone helpline, where somebody who is apprehended and brought to a police station can ring a designated lawyer and obtain advice as to whether or not he or she should speak to the police or not. Well, what is any sensible lawyer going to do in that situation, knowing absolutely nothing from the other side of the argument from the police? So I can't see that being a terribly successful proposal. But that's as far as the government's gone so far. They're still thinking about it. One of the things that I hear mentioned in some quarters is that they might limit this abrogation of the right to silence to only certain very serious offences. How on earth does that help the rights of the accused? It's in those very serious offences where the greatest harm might be able to be done by infringing on the right to silence in this way. So, we wait to see what developments might come from there. Serious violent offenders. There is again a government proposal, and I'll deal with this one very briefly. Proposal to legislate in much the same way as serious sexual offenders have been addressed in legislation, to enable serious violent offenders who do not undertake rehabilitation programs while in prison to be subject to continuing detention in prison or extended supervision in the community. Now, that was a scheme that was introduced for serious sex offenders. It operates in New South Wales and Queensland and Victoria, I think maybe in one or two other states as well. It has been challenged. A Queensland and a New South Wales case were taken to the Human Rights Committee of the United Nations. And the Human Rights Committee found that it was contrary to the International Covenant on Civil and Political Rights, at least because it could amount to arbitrary punishment. There were some other arguments as well that were addressed in those cases. The Human Rights Committee gave its report to the federal government. The federal government tossed it around for a year or two and then decided to do nothing to change the law. They didn't agree with the Human Rights Committee's findings. So now a similar kind of proposal is being put forward for serious violent offenders. Now the New South Wales Sentencing Council produced a report on this not so very long ago, and I am still a member of the Sentencing Council. But in its report, it put forward, and they're in the paper for you, 7 particular recommendations in relation to this suggested regime for serious violent offenders. The government at the moment has picked one of those out of the context of the other 6 that would provide some checks and balances, some protections for the exercise of that one that they've picked out. And I think it's quite wrong for the government to cherry pick amongst a suite of recommendations that sit together consistently to do something that they think might be politically popular. Now, time is running, and the final thing that I do want to say something about is drug law reform, because I really do believe that it's an issue whose time has come. There is a lot of agitation in many parts of the world for changes to the present regime of prohibition. I mentioned just in the recent election, Washington State and Colorado, who have gone that extra step. There are 17 states in the United States of America in which it is already lawful to obtain cannabis for medicinal purposes, under regimes that are very carefully controlled and licensed, although, yes, there will be some medical practitioners who will sign a prescription for almost anybody in almost any circumstances. You will always get the envelope being pushed when you introduce measures of this kind. There are also some European countries, Finland, the Netherlands, even Israel has a medicinal cannabis program in place. So the people who are suffering, for example, nausea as a consequence of chemotherapy and some other kinds of pain can have access to the THC in cannabis. So things are changing. There's a website you can go to of the Beckley Foundation in England, which actually describes and lists the jurisdictions around the world where drug law reform is happening, where various kinds of drugs are becoming available under various conditions. It's a long argument, some of which is set down in the paper, and I've given in the paper references to websites where you can see a lot more information about drug law reform. But the propositions that lie behind what I'm saying, I think, are these, and I'll just go through these because I think they're important. There have always been, there are now, and there forever will be, drugs, substances that alter the mood and the mind when ingested. It probably began when somebody pulled a plant from the ground and chewed on it and discovered that it gave him or her a nice sensation. It may have begun when somebody ingested fermented vegetable matter with alcohol in it. Who knows? But there have always been drugs that change people's moods, and people like to do that. There will always be people who want to consume drugs. When I say drugs, caffeine is a drug. Caffeine is just subject to ordinary health laws. It's not subject to any restrictions, like alcohol or nicotine. There will always be people who want to consume drugs. And there are lots of reasons for it. Some take drugs to relax, some to heighten their excitement, some take them to escape from life, when life becomes too burdensome. Some do it to engage with their peers, to be part of a group. Some take them to aid in contented reflection. Some take them to rave. And some deliberately choose to consume drugs, and some are sucked into it or drift into it. There are all kinds of ways in which people come to drugs. Many become addicted. I'm a criminal lawyer, or I have been a criminal lawyer. What's the criminal law got to do with this? Now, there is demand and there is supply. When you have demand and supply, you have a market. The market for some drugs, not all, the market for some drugs is unlawful. And persons involved in that market therefore run an increased risk of official detection, prosecution and punishment. There's a risk that if you don't get away with operating in the market, something bad might happen to you. And to compensate for that risk, the price goes up. And when the price goes up, the profit goes up for those who get away with it. You can buy a kilo of heroin in Bangkok for $1,000. You can sell it in Sydney without too much trouble at all for $300,000, if you can get it in. We have something like 2 million shipping containers coming to Australia every year. We search something like 4,000 of them. And that's the way that most drugs come into Australia, the imported drugs these days. The consumers run the risk of involvement in the market because their desire for drugs is strong enough to encourage them to run the risk. And they're often unable to meet the high prices that are fixed by the suppliers. Their assets don't extend to that, so they come looking for yours and for mine to convert into purchase price. Consumers are also at the risk of official sanction. The maximum penalty for administering or attempting to administer a drug, including cannabis, to yourself is 2 years imprisonment. People consume drugs in secret, and particularly in the case of injecting drugs, the conditions in which they do that are often unhygienic, the equipment they use is often unhygienic, and disease and death can follow the ingestion of the drugs. Consumers in this unregulated market also do not enjoy the benefits of market and product controls. They literally do not know what they are consuming. It's always amusing to me to have cases sent to me as DPP where somebody had been detected at King's Cross or a pop concert or a rave party or somewhere in possession of drugs, usually tablets. And they thought they had ecstasy or amphetamine, some form of upper that would give them a bit of excitement at the concert or the nightclub or wherever it was that they were going to. And they'd been detected by sniffer dogs, and the sniffer dogs had reacted positively, and the police had found packets of pills in their pockets and that sort of thing. They'd be arrested, charged, taken to the police station, released on bail, required to come to court at a certain time, etc., etc., etc. In the meantime, the drugs were sent off for analysis by the chemist. Back would come the analyst certificate, no drugs detected. You really don't know what you are getting when you buy illicit drugs. It indicated to me that there are an awful lot of rip-offs going on out there. And people who think they're getting drugs are getting caffeine or sugar or something totally harmless. But it can work the other way too. And people can get dosages that are stronger than what they're used to. They can get dosages that are contaminated by chemicals of one sort or another. Or indeed, there have even been cases where heroin has been bulked up with cement, if you can believe that. And of course, when people inject these things, they suffer enormously as a consequence, sometimes die. And in the meantime, the successful suppliers of all this stuff, because of the high profits that they earn, can pay law enforcement to turn a blind eye. And corruption occurs, as we know from royal commissions, we know from commissions of inquiry, that around the drug industry in particular, there's an enormous amount of official law enforcement corruption because of the high profits that are involved. So, what do we do with a situation like that? And my suggestion, and the suggestion being taken up by many others around the world, when I say taken up, I don't mean from me, I'm a latecomer to this movement started a long time ago. But in Australia, there's a group called Australia 21, which you may or may not have heard of, which has published now 2 reports on this subject. I brought 4 copies of the report along this evening, so if 4 people really want a copy of the report, you can come and see me afterwards. This is the second report that came out in September. And it has a number of specific recommendations in the report about how we should be addressing this question of the drug trade and use. It seems to me that the only way that we can effectively deal with this problem, and it is a problem, is to take over the market. For the government to legislate, regulate the supply and distribution of drugs, control it, and tax it, to enable the criminal element to be sidelined. The criminal element won't disappear altogether. There'll still be those chancers out there who think that they can still make a profit through illicit supply. But they will diminish, and their influence will diminish as the legitimate market takes over. And if you make it legitimate, if you get it out into the light, you can expose the people who are using drugs to the facts about it, to support, to assistance, to medical treatment, much as we see happening with the medically supervised injecting centre in King's Cross. It seems to me ridiculous that there is one such place in the whole of Australia, which has now been running for 11 or 12 years. It's now being put on a permanent basis by the government, and it's done fantastic good in its time. It has saved literally hundreds of lives. The lives of people who then can be referred to appropriate treatment regimes, support services, and get their lives back on track. Because it's, I think, well understood that if you can keep a drug user, even an injecting heroin user, alive for a number of years, they will eventually stop using the drug. You just need to get to them, to keep them alive, to put them on the right track, to enable them then to get off the drug and back into a drug-free life. Yeah, we've had successes. The needle and syringe exchange programs, the methadone programs, those sorts of things have been an outstanding success in Australia. But I think we really need to do more, and the time has come. Now the politicians, understandably, back off. It's all too hard, too controversial, too radical. We can't go there. And that was the reaction of the Prime Minister when the first Australia 21 report was produced in April, May this year. And I think the only way that the politicians' views will change, and I know that there are a lot of politicians who do feel that there should be a reform, I think the only way that effective change is going to happen is if enough members of the community demonstrate to them, our representatives, that this is what the community wants. So there needs to be that campaign to instruct and inform politicians so that they will feel confident about putting their heads above the parapet and taking steps towards drug law reform. Ladies and gentlemen, I think I have occupied your time for quite long enough. I wouldn't want to stand between an audience like this and some drinks outside. So I simply say again that there is a lot more detail, a lot of other information relevant to what I've been talking about in the paper, which you'll be able to access later on. Once again, I thank you for your attention. I thank you for the privilege of being able to speak to you this evening. I hope that even one or two little thoughts might have occurred to you and that you might be in a position to take them forward and do something about it in the future. Thank you.
It's now my duty to say a vote of thanks. I just want to start tonight by acknowledging the many members of the Marsden family we have with us this evening, to thank them. Jane, Jim, Louise, Grania and Sally, I believe, are here tonight, so thank you very much. It's good to see you. And I just want to say a few words and reiterate some of the important points that I took from Nicholas's wonderful speech tonight. I just want to start by saying, as a Director of Public Prosecutions, he was widely respected. Not only was he the longest serving Director of Public Prosecutions in Australia, but he was fiercely independent, as Jim said, and he discharged his duties in an impartial, distinguished manner. Not only that, he also importantly contributed to the public debate and discourse in areas where the law required urgent reform. And I think it's important to acknowledge that he often did that while he was in office. I'm pleased to see tonight that he hasn't lost any of his zeal, and perhaps he's an even more vigorous advocate now for reform than he was while he was DPP. Now, tonight's lecture, I think, has provided us with a wealth of information in a clearly articulated, compelling and rational analysis of the 5 topics that were briefly discussed. I expect nothing less from Nicholas Cowdery, and I think it's worth going over a few of the points that he made tonight. There were 3 in particular that struck me that I just want to reiterate. 2 of them he spoke about tonight, and one of them is in the paper that I've had the benefit of reading, and I urge everybody to obtain a copy of that from the Council for Civil Liberties website once it's put up there after tonight's lecture. I think the first point that really struck me was what he said about bail. In that, I quote, he said, "It must clearly be understood, and it's often forgotten by commentators, that bail has nothing whatsoever to do with punishment, which comes to be considered only after conviction." End quote. Now, to me, it's absolutely incredible to see both the number of commentators, more importantly though, the number of ordinary members of the community that I have discussions with who fail to see that point and somehow sincerely believe that if somebody is granted bail, that they've somehow escaped punishment for a crime. I think it's always worth reiterating the point to people that bail actually doesn't have anything to do with sentencing, because many people misunderstand that. I also like the idea of being smart on crime. I think that's a very good way of arguing about law reform in the context of getting away from this position where we continually have people's rights being eroded. But the second point that I want to reiterate tonight was the point he made in relation to the right of silence. where he says an important problem with the tailment of the defendant's right to silence is that there is no requirement for the police to inform the defendant of the evidence available against him or her. And I think that's an important point, because the government's now expecting defendants to disclose information and disclose it in a context where they may not know all of the relevant facts. And it really demonstrates that there's not a level playing field, because the police may know information that's relevant to the crime, not disclose it to the accused at the time they're questioning them, yet expect that the accused is supposed to disclose what they know, otherwise have adverse inference drawn when it's later used or relied upon in proceedings. It's not a level playing field, and this is just likely to entrench disadvantage and do so in the most serious of criminal matters, if that's the way the government proposes to proceed. The third point that struck me in the paper, which you should obtain a copy of, was about the so-called war on drugs. Where in the paper, Nicholas Cowdery says, and I quote, "Why is it thought that if prohibition will not work for alcohol or for nicotine, it will work for less harmful drugs like cannabis and ecstasy? The approaches we have to drugs are neither consistent nor rational. We do have some success with the drugs we treat openly. We have no success with those we seek to suppress completely." And I think it's a very important, that's end quote, I think it's a very important and valid point. Now, recently, Nicholas Cowdery has been very outspoken on the issue of drug law reform. And I think it's important to acknowledge that we lost the war on drugs, the so-called war on drugs, decades ago. Perhaps even lost it as soon as this war began. And the time's come now where we have to engage in alternative solutions. The sooner we see drug dependency as a health problem rather than a criminal matter, I think we can then deploy the significant resources that I believe are wasted on police and prosecution in ways that are much more productive and fruitful in terms of treating it as a health problem. So look, they're the 3 points that I took out of tonight's lecture, and I want to end by saying simply that I'm certain that John Marsden would be proud to know that you delivered tonight's lecture. I don't think you'd hold it against you that you're a director of public prosecutions. I always knew him to be someone who was fierce himself in terms of criminal law, someone who always stood by his principles, and I think he'd be looking down, smiling, knowing that somebody tonight that shares the same vigour and the same approach to matters of principle has delivered a very eloquent lecture. So I want to thank you on behalf of the Marsden family and the New South Wales Council for Civil Liberties for such a thoughtful and provoking lecture. And I also want to urge you to keep up the good work. More of it needs to be done. So please join me tonight, everybody, in thanking Nicholas Cowdery. Look, there are refreshments outside. Please join us for refreshments and a chat. Thank you very much, everybody.